Hello, everyone. Welcome to Net Diligence Virtual Cyber Risk Summit. My name is Heather Osborne, and I'm the Director of Global Events and Programming at Net Diligence, a cyber risk assessment and data breach services company. Net Diligence is pleased to bring our thought-leading content to the virtual space with this new webinar series. Visit our website at www.netdiligence.com to get more information about our upcoming webinars and in-person events. Before we begin, I'd like to extend our heartfelt gratitude to our virtual Cyber Risk Summit sponsors, particularly Aspen Insurance, our diamond sponsor. I'd also like to thank our 100-plus speakers for bringing their thought leadership to our program. For today's webinar, we will be using the On24 platform. Right now, you should be viewing the On24 dashboard, which shows the live viewing screen. During the webcast, all participants will be in listen-only mode. Today's presentation is slated for approximately 45 minutes, with 15 minutes at the end for questions. Our panel of speakers will be taking questions throughout the session via the Questions widget. Please type in questions during the presentation and click Submit. If your question is of immediate import or concerns technical problems, you will receive an immediate answer by text. You can also find a widget entitled Resources, where you can download assets provided by the speakers and sponsors for each webinar. Just click the resource in the box and it will be automatically downloaded. If you are interested in receiving CLE or CE accreditation for this program, you must stay on for the full duration of the webinar and answer 3 polling questions that will appear during the course of the program. Additionally, please fill out the participant information questions. This will ensure that you are correctly matched to the state and professional organization. As a reminder, this webcast is being recorded. After the presentation, you will receive an archive link for further review or for sharing. The webinar will also be available for future viewing on our website. Again, thank you for joining the Net Diligence Virtual Cyber Risk Summit. We hope you enjoy the program.
Hi there. Good morning, good afternoon, and good evening, wherever you may be in the world, and welcome to the Reasonable Cybersecurity panel. I'm Andy Maher, Senior Underwriter in the Global Cyber and Technology team at Axis, based in London. During this panel, we will be discussing the risk-based analysis process that substantiates a method of reasonable security. The panel will provide opinions from security, legal, and regulatory perspectives. Anyone who's spent time reviewing or reading data privacy or data security laws would have come across the term reasonable security or appropriate security. These terms appear in some of the most prominent data privacy laws, including HIPAA, FERPA, GDPR, and CCPA. Reasonable cybersecurity may sound like a loose term that's open to interpretation in comparison to, say, the New York Department of Financial Services cybersecurity law, which explicitly states controls and securities that must be in place. But is that the point of the term? That's certainly something that we'll be exploring on this panel. So without further ado, I'd like to ask my panel to introduce themselves in the order that they appear on this slide. Chris, if you could start, please.
Yeah, hi, this is Chris Cronin. I'm a partner at Halock Security Labs.
Hi, this is Doug Meal from Orrick. I'm the co-leader of Orrick's privacy and cybersecurity practice, and I lead the litigation and regulatory enforcement side of the practice, where I spend most of my day defending companies that are unjustly accused of violating their legal obligations for cybersecurity.
Hi, this is Tim Murphy from the Pennsylvania Office of Attorney General. I lead most of the data privacy cybersecurity investigations throughout the Commonwealth of Pennsylvania.
So we're going to start with a poll. Reasonable cybersecurity is a fixed standard and an easy concept to understand and with which to comply. Please choose true, false, or unsure. If unsure is the winning vote, I hope we can provide some clarity through this panel. So the agenda, we're going to go through terms and definitions, various standards of reasonableness and duty of care, risk-based analysis and best practices, communication to and working with the policyholder. So it's the legal test for deciding the question of reasonable security. Tim, if you could kick us off, please. I mentioned earlier that reasonable security seems like quite a loose term. How has this term evolved over the years, and does it need to be a loose term to remain relevant?
So thanks, Andy. Yeah, in my opinion, it is a loose term, and the reason for that is it can't be prescriptive because of how technology is evolving. What technology was 5 years ago is like being in like the dark ages. And just give an example, like standards of encryption, what used to be the standard are now considered things that are insecure. And I would think this is why the FTC does not define reasonable security when they are entering into consent decrees with companies, because their consent decrees are enforced for such a long period of time, and technology will evolve. And I think the FTC's found that problem they found that in LabMD, and so since then, FTC has attempted to provide more clarity around what is reasonable. Pennsylvania tries to, and all other attorneys general are trying to come up with what is reasonable data security, but it's always such an evolving term and so forth. And I'm sure Doug would disagree with me that the FTC's attempt of more clarity is not so since the post-LabMD, and they're trying to provide clarity to what is reasonable security.
Doug, do you care to disagree?
Probably the first of several times that Tim and I will lock horns on some of these issues. In terms of the question you asked, Andy, it isn't just a loose term. It's essentially a meaningless term. And actually, that's what the 11th Circuit held in LabMD. In that case, the 11th Circuit said that the FTC, by ordering companies to have, quote, reasonable security, close quote, in place, but not defining what that meant, made the order unlawful and unenforceable. And so what LabMD teaches us is that if the standard is going to continue to be reasonable security, and you mentioned, Andy, a number of places where it is currently the standard, there needs to be a definition, a test, something around that term, reasonable security, that enables companies and litigators and regulators and security consultants like Chris to know before the fact what they need to do in order to achieve that standard.
Yeah, so I mean, we've noted there that no such consensus currently exists, and you've hinted at why it might be. If each of you could give kind of your main points or opinions as to why no consensus currently exists, that would be great, please.
Well, I'm happy to kick it off and then turn it over to Tim and Chris. But the reason why no consensus currently exists is that, as Tim sort of alluded to, no regulator, no legislature has been willing to enact a regulation or enact a statute that defines what reasonable security means, even though the statute or the regulation may require it. And as of yet, we haven't had any court anywhere in the world try and define that test. And so there's no consensus because there aren't any really operative definitions or tests out there, the way I see it.
This is Chris jumping in. I agree. I'll add to that, and this will actually go toward the next question: could one emerge? But I'll add to that we decide about what reasonableness is in a form of contention usually. It's when people disagree. What's so interesting to me about the question is that information security folks, litigation folks, regulatory folks, each have a common understanding of how you would evaluate risk, the foreseeability of harm, and then use that requirement that some evaluation of the foreseeability of harm come into a determination of whether someone applied due care or not. But if I look at information security and have conversations with litigators and regulators, they'll all ask about this common question. Did we look at the foreseeability of harm? I think we have the tool set to have a consensus emerge. And I've had the good fortune to work with both Doug and Tim in different capacities trying to define this definition of the word. And I'm hopeful that one can emerge. I think one of the contributing factors to one not emerging so far is just the fact that the question often comes up in a form of contention, two people disagreeing.
Yeah, and these statutes, they make for what I like to say, great law school exam questions, right? You could argue it, I could give half the class, argue for the regulator's perspective and half the class as the defendant in why they had reasonable data security. And part of that is the problem with the latest statutes that have come out. I mean, New York is the latest one with the SHIELD Act. They at least go and provide some examples, but they don't mandate anything specific. And there's all these murky language with minimum. And is that like a baseline? So if you hit so there's no real standards that are in place for people to look to. And it just, I think that's what everyone struggles with these investigations, because it really just comes down to lawyering. And really that's what's been so tough for, probably on the defendant side, explaining that to the client, where the client probably is saying, what do you mean? You don't know, I mean, what this is going to turn out if we went to litigation with this. So, yeah, I think that's the reason why nobody's really stepped up, even from the legislature standpoint, to provide, simple safeguards that would determine what is reasonable.
So in order for one to emerge, we might have to see defendant lawyers and regulators agree on something.
Or a judge rule. Because I think when cases start coming down, and they will start coming down, as this is such an important issue under so many different statutory and regulatory schemes, there will start to be judicial rulings. And I think what will affect those judicial rulings, frankly, is thought leadership coming out of panels like this, and articles get written, and efforts to look at how reasonableness has been evaluated in other contexts and try to carry those over to this context.
That's a great point. Let's move on to the next slide. So, why defining how to decide the reasonableness of security matters? As we can see from this slide, reasonable is a standard for different things in litigation, regulation, and information security. Doug, in your opinion, can reasonable security be interpreted differently based on jurisdiction? The EU has GDPR and the USA has CCPA, amongst other such legislations. If they can be interpreted differently, how challenging could this be for global companies that are exposed to both?
So it shouldn't be. Right, because if there is a test for reasonableness that makes sense, and if a consensus emerges, there isn't any inherent reason why you should have a different outcome under GDPR as compared to CCPA, for example, both of which effectively require reasonableness. But the risk is that that California may adopt one test for reasonableness, and in Europe, a different test for appropriateness or reasonableness might be adopted, and that's where you could have different outcomes in different jurisdictions, which would be, yes, a truly nightmarish scenario for companies that have to meet, in effect, every jurisdiction's requirement.
So it's similar to the age-old story. If you have a data breach in the US and you're having to comply with 50 different breach notification laws, and if it's healthcare data, HIPAA, that could be, the same for an EU and a US event. and the importance of a specialist attorney in the privacy and cyberspace prevails. Chris?
Similar, but worse, actually, because the stakes are so much higher in terms of the reasonableness question, because you lose that question, you could be held liable for the entire breach, and the liability there is astronomical potentially compared to liability for delayed notice.
Yeah, and then the fines and penalties that could ensue. Chris, does reasonable security change based on industry sector or size of company? And I was talking about jurisdiction. I'd love to get your opinion on industry sector and size of companies. We've seen with HIPAA, and sorry to bring it up again, that the size and economics of a company is factored in. Should reasonable security be applied in the same way?
Well, yeah, so when I talk about reasonable security, I think about two different things. And we'll actually talk about these two different things the same way on this panel, I think, is that there's a difference between a reasonable process. Am I acting with due diligence? Am I applying the right level of conscience and analysis for prioritization? Have I thought through the kinds of harm that could come to people and myself? Am I prioritizing my concerns, and am I putting controls in place that are no more burdensome to me than the risk that they create to others? This is a process, and this is reasonable, right? And so that's pretty consistent across. In my mind, I would want an organization to show a reasonable process. Now, are the controls that we apply and the priorities that we apply different organization to organization? Absolutely. You can just look at the Verisk Community Database, almost 9,000 records of publicly reported breaches, and break these causes of the breaches down by industry, and you'll see very distinct patterns. There are some risks that are much more common in certain industries than others. Even within an industry, if I were at two commercial banks, I know they're going to have different risk levels and two different tolerances for reasonableness, which is why each organization has to do its own risk assessment. Like, I'm not going to give you an industry risk assessment that you fall under. Each has to do their own. So there is a lot of variability in what a reasonable control is based on the foreseeability and harm each organization can do. So that's always different. Industry by industry, even organization by organization, that'll be different. But the process by which we identify whether we're doing something reasonable, what you might think of as due diligence, I think I apply the same rule across industries. Let's put it that way.
Good, Joe. Thank you for that. Essentially, on the liability and the litigation side that can come out of going back to what you said earlier, Doug. You know, how can you see reasonableness really applying this to an insurance perspective? How can reasonable security really help policyholders if a claim were to come in?
Well, if you can achieve it, it helps policyholders because it enables them to avoid liability where they might otherwise have it in the event of a cyber incident. And for that matter, it obviously helps insurers as well. Up till now, the issue hasn't really come to a head in any litigation under a cyber insurance policy because the focus has been so much on proving injury and whether injury could actually be proven in these cases. But that's disappearing. CCPA, with its statutory damages remedy, at least where that applies, eliminates the injury inquiry. Similarly, the injury inquiry isn't relevant in terms of whether you have liability under GDPR. So, and we have developments in, at least in the UK, which is also in terms of the potential Lloyd v. Google situation, would also make injury, in effect, irrelevant and damages irrelevant because they're predetermined. And so this is going to become an issue over the next 5 to 10 years, as the injury issue kind of recedes, that will come to the forefront, and it'll become crucial from both a policyholder perspective and an insurer's perspective to figure out how best to, in effect, prove up the reasonableness of the insured's security.
And as we can see from net diligent cyber claims allocation graph from 2014 to 2018, the bulk of the cost in a claim were from the litigation and regulatory side. So really achieving reasonable security should reduce these full liability claims allocations and therefore greatly reducing the claims costs for insurers, which is what we love to see.
Yeah, and Andy, this is Chris, just real quick on that point. This, I think, is a really interesting takeaway for insurance. If we're actually investing in risk engineering, that we're showing a risk-based process for addressing risks over time with our clients, those liabilities should go down. So even if we don't have the best handle on preventing breaches because hackers are so clever, I think we can reduce those liability costs through risk engineering services. That's certainly what's Halock's experience in post-breach scenarios, speaking with regulators, whether we're on the defense or supporting the AG, that when someone has on paper a demonstration of risk-based prioritization and diligence on issuing controls, that liability goes down. So I think it's an interesting takeaway to consider here.
Yeah, that's a really good point to make. Thank you, Chris. Yeah. We continue to explore why defining how to decide the reasonableness of security matters. Tim, I'd love to get your perspective on whether reasonable security is defined by the last settlement an Attorney General entered into, or at least from a Pennsylvania standpoint.
Yeah, so back in December, the Commonwealth of Pennsylvania settled with Orbitz and Expedia involving a breach from March 2018. And one of the things that I tried to craft into the settlement was for the first thing is to start off with. Now, I guess the requirement is, before I get into what's needed, it's, the company needs to have reasonably designed a security program to protect the security, integrity, confidentiality of the personal information it collects. And then at a minimum, the requirements set forth in the rest of it based on a relevant risk assessment. And so all settlements going forward are going to involve, are going to have a comprehensive risk assessment, because that's where we're seeing the company has just failed. The risk assessments are not thorough. They are check the box. There's no thought process that really went into the decisions that were made in a lot of these. And I'm not speaking particularly for this particular settlement. I'm just talking about in general. But the companies, we want them to have a comprehensive risk assessment and we want them to do a cost-benefit analysis, which kind of what we're going to talk about in a little bit. And we asked them to document the criteria, just like not just in information security standpoint, in other aspects of things you need to show documentation. And so we want to see that they're documenting documenting that they've thought through things, like do they think about the obligations that were owed to the consumers? Do they think about the social utility of the company handling the consumer's information? Did they take into account all the foreseeable risk and harm that could be caused by these security threats? And, just those are the things that we have. And then we want to see a plan that they've put into place moving forward to reduce these risks. And if the company comes to the conclusion that they can't implement some type of safeguard, we want to know why they thought it at the time. And it shouldn't just be based on money. It should be looking at what's the trade-off to the harm that they open up to it versus, is it going to be detrimental to the company in itself?
So really going through a risk analysis and providing a rationale out the back of this analysis as to why you didn't implement certain securities policies and procedures, or why you did implement those securities policies and procedures. And so, you're looking to see the rationale out the back of a risk-based analysis, correct?
Yeah, and Chris has worked with me on some things, and really it just, a lot of things we just see are these check the box, and or they are getting penetration test results or vulnerability scans, and you just see failure after failure where nothing was done over time. I mean, it was just a sitting duck waiting to happen, and the company was just taking no action. They actually make the cases really, by not doing any of this and doing check the box and say you have everything when you really didn't, and just going through, you're pushing the paper that just sets you up for the problem, like with this liability, where it's just going to be proven wrong of what you laid out there. I don't know, Chris, would you agree with that?
Yeah, yeah, of course, yeah. And what I think is really important about your injunctive order against Orbitz from December is that it's the clearest articulation I've seen yet of the tie-in between doing a risk analysis and demonstrating reasonableness. And at no point are you saying that I will only accept this control if it was never breached. You're saying I need to see that you thought through why something was a level of foreseeable magnitude of harm that we could have accepted, or why other controls would have been overly burdensome. And I'll have you know something kind of fun too, is that since that very clear articulation, there's a state Senate bill in Illinois for their data security bill that uses a very similar articulation as to what you've got in that injunctive order, Tim. So someone's paying attention.
That's good to know, because we released it in Christmas on a Friday, so I didn't expect anybody to read it.
Someone's paying attention.
Very good. So we talked about a lack of consensus earlier. What might such a consensus be based on? Let's dive back into that slightly. So, Doug, does compliance with other standards, such as the payment card industry data security standard or New York Department of Financial Services cybersecurity law, equal reasonable security in your mind? We've just been through risk-based analysis to then lead to obtaining reasonable security. In your mind, would compliance with either of these standards get a company there?
I would say no, because it wouldn't eliminate the possibility of some other means, perhaps the cost-benefit type of analysis that we're going to discuss later, being used to attack the reasonableness of the entity's security. But I will say that if you can show compliance with an industry standard, take PCI DSS as an example, if you can show, or better, if your adversary can't show that your conduct was violative of some applicable statutory or regulatory requirement, a specific requirement, such as the encryption requirements that are in place under certain statutes and regulations, it does become very difficult under established principles to show unreasonable security, because in other legal contexts, what really informs the reasonableness inquiry in lots of cases is the court looks to industry standards, looks to statutes and regulations that govern the defendant's conduct, and will be willing to find that you acted unreasonably if you didn't live up to an industry standard or an applicable statute, but very hard-pressed to make that finding if you did. So is it dispositive? No. Is it a crucial issue? Yes.
Thanks, Doug. And Chris, I think you might have already answered this question, but for you, which is a better approach for companies to take? You know, a CCPA kind of approach or an NYDFS stated controls and securities approach?
Yeah, I think my answer is very similar to actually what Doug is saying too. I always stress that people need a standard of care. What controls are you applying? And make sure that you've got a good industry basis. A security community like Center for Internet Security or the PCI Security Council, National Institute for Standards and Technology, some organizations that are super focused on letting you know these are the kinds of things you should be doing. Have that standard of care with you and work at it. But you're going to find that in some cases you just cannot apply those controls all at the same time or as written. That's when you do your risk analysis. And I think that's very much in line with what you're saying, Doug. In this case, if I'm looking at CCPA saying, reasonable, security controls that reasonably protect data, or if I look at NYDFS, I see something very, very similar. NYDFS, where it does state specific controls like encryption or multi-factor authentication, it says risk assess, right? You need a risk-based reason why you're applying the controls that you're applying. So where people say NYDFS shows some specific controls, kind of it does. What it's really doing is saying, make sure that you've thought these through, find a risk-based approach for getting it right for your organization. So I think in that way, if you're doing CCPA with a generic statement or NYDFS with more specificity, or even CIS controls that are very specific, either way, someone's going to have to eventually say, what is my standard of care I'm applying? And how do I evaluate the risk if I can't apply it exactly as written?
Yeah, it's a good point, bringing in the CIS controls there as well. They are very, very specific. Yeah. We're going to move on to our second poll of the panel now. Who do you think you should ask to determine whether you or a client of yours has achieved reasonable security? A lawyer, a regulator, or a security expert?
We should have included in there all of.
Yeah.
Exactly. Oh, yeah, we should have.
Should be that would be a great answer, right? Exactly what I was thinking, right?
You can all post your individual answers via question if you want to go with that one.
Yeah, frankly, all three of us. You just ask all three of us now. Go ahead.
We'll leave that for the end. Let's dive into the outcome-based models. And I am going to ask all of you because I know they're all going to be very different answers. So how do each of you think the traditional outcome-based models work in practice? Doug, let's start with you.
Yeah, and I'll just briefly add to what I said earlier. I'm speaking about this from a litigation perspective. And in practice, as I said earlier, if you as the plaintiff can show a violation of industry standards or a violation of an applicable statute or regulation by the defendant, that gets you a long, long way towards persuading a court potentially of the unreasonableness of the defendant's security. But want to mention here that it's not that easy to prove either of those, because the test for whether something is an industry standard is actually a very, very high bar in the case law. So we were talking earlier about, this is in the context of the process-based approach, about having an expectation that a company would have in place a particular type of process, do risk assessments, things like that. There's no industry standard to that effect, at least in my opinion, using the test for an industry standard that the courts have followed. And so, in my view, in an adjudicated scenario, showing that someone didn't follow a process of the sort that Tim was describing, or the sort that Chris was describing, wouldn't get you anywhere, shouldn't get you anywhere, because you're not going to be able to prove that there is an industry standard to that effect in regard to the process that should be followed. It might be something that a regulator likes to see, but there isn't any industry standard that could be proven up there, in my opinion. So in practice, while these offer a theoretical real advantage to a plaintiff's lawyer, in reality, they're not as successful as one might think.
Sure. Thank you, Doug. Tim, can we get your opinion, please?
So one thing about the industry standards, and we've mentioned PCI DSS a lot, and I think it's important to state that PCI DSS is a minimum set of requirements, and they use that language in the latest version of the PCI DSS. And they use terms like baseline. And they also punt it where it may be enhanced by additional controls and practices to further mitigate risk, as well as local, regional, and sector laws and regulations. So the industry standard, if you were talking about minimums, if it's the minimum, just the absolute floor to get to, like all these laws with CCPA, GDPR, they would disagree with that was by you fulfilling these minimal requirements, you would get a pass. And the same thing, that would be our perspective from a regulatory standpoint in Pennsylvania, as far as as far as we're looking for violations, not necessarily the harm that you see is discussed fully throughout. With regards to a lot of things that Doug sees in the litigation aspect and so forth. So I don't like to say that there's an industry standard approach or that companies that should be what they should be based on, because by just doing the minimum, if you're not doing the assessment to see where you are what you're vulnerable to hackers, and you did not take care of it, then I would still think that you had unreasonable security, and therefore, there would be moving along from a regulatory aspect of a violation. So a very brief counterpoint there. Forgive me, but picking up on the point I was just making, there's a very strong argument that PCI DSS is not even an industry standard. It's really a card brand created standard, and it was created for the purposes of moving money from merchants to banks in the event of a data security breach. The vast majority of merchants are not in compliance with PCI DSS. It doesn't fit what the courts say needs to be the case for there to be an industry standard. So this illustrates the point that proving up a true industry standard in this context would be very, very, very difficult.
Yeah, and before we go for it.
Yeah, sorry. Yeah, so if we're going down that road, I'll burst everyone's bubble. I see three kinds of looking at in practice from the cybersecurity perspective. There are three kinds of organizations: those that don't care and don't try, those that use something like an industry standard document, like PCI DSS, and they sort of rationalize why they're not doing everything through negotiation or just shrugging their shoulders or say, I think the risk is low enough that I don't have to do it all. And then the third is people who really are trying to get things right. They've got a risk-based process, etc. And if there is an industry standard based on maybe industry custom, and I think of what you're saying, Doug, as industry custom, because I think standard for me is a trigger word. It means that the members of the community developed a set of rules. When I think of industry custom, I think, well, the first two groups of organizations lie, and that's the custom. And then the third really tries hard to get it right. And I certainly don't want people saying, yeah, we found ways to rationalize our way to not do everything as a standard either, even though that's very common. And I think one of the big concerns that I've got is in the commerce aspect of information security, including how it relates to finding the right cybersecurity insurance policies, is how we know whether someone's actually doing something the right way. So if they say, oh yeah, I followed PCI DSS and I got audited by an auditor who may or may not have been competent, and we've all seen that challenge. So I'm good. How do you even know whether someone has applied this industry standard in a way from a commerce perspective? Am I allowed to do business with this person? Am I doing the right thing by doing business with this person? Becomes the wrong rabbit to chase, which is why I keep going back to people. Look for the clues that someone's doing due diligence, that someone's looking for the problems and they're trying to find solutions to the problems. If we're stuck with the standards, did you go down the checklist? Yes, I did. And I had a CPA actually evaluate that to be sure that I got it right. I'm not confident in that result at all. I want to know, do you have evidence that you're looking at the problems? And that you're looking at the risk that those problems pose, and if you put controls in place that address those problems. If I see someone who's applying that effort, that gives me an understanding that they're probably in that third class.
Yeah, I was going to say let's not dive down the PCI DSS rabbit hole, but let's on that note, let's move on to what I know is this panel's favourite topic. Cost-benefit approach. You're all chomping at the bit to talk about this one. So we're going to start with Chris. So Chris, how would a cost-benefit approach work in a data security context?
Yeah, so there are two ways we've applied it. One is when everything's going great and you're trying to manage your organization, and the other is after there's been some kind of breach and you have to determine whether or not an alternative control that someone says you should use would work. But the principles are the same. And lawyers would recognize this as being tied to the learned hand rule, that you figure out whether a control is reasonable by comparing the burden that a control would create to the likelihood and the impact of the problem that you're trying to prevent. Regulators could tie this back to, at least federal regulators, to Executive Order 12866 back in 1993 that says all regulations that we apply will have this cost-benefit analysis. And then you see regulations after that stamping in this requirement for reasonableness and risk assessment. It all comes from this Executive Order in 1993. And then in information security people, we say, I'm going to do my risk assessment. I got to look at the likelihood and impact of problems. But then I'm going to compare the risk of the control I'm proposing to the risk that it's trying to address. So when I'm working on my preparation for cybersecurity, I'm managing my organization and I haven't had any breach, so I don't have to explain myself to anyone. I'm looking at the likelihood and impacts of problems, and I'm looking at the controls from my standard of care, my control standard, to say, what should I be considering here? And if I see right away, that's going to be hard to afford, or boy, that could really hurt the utility, my operations, the benefit I provide, I have to figure out a risk-based way to address this issue. So that's one way. That's a cost-benefit approach. Afterward, and this is something that Doug and I have talked about quite a bit for other purposes, we could, let's say there is a breach, and then plaintiffs or a regulator come after us and say, you should have used this approach instead. You should have used this control. We can actually do a comparison to say, is the benefit of using that alternative control greater than the cost it would have been to apply the control? So same cost-benefit logic, just used in two different methods given the timing of a breach.
Thank you, Chris. Doug or Tim, would you like to weigh in on this from this perspective?
I'll just weigh in briefly and say that the attractiveness of a cost-benefit approach in this context is that first of all, as Chris mentioned, it has a legal basis, right? It's the same sort of approach that is used in other contexts for evaluating the reasonableness of conduct. So that makes it very, very attractive to a lawyer, at least, because you're dealing with something that the judges are familiar with. Whether that approach could ever really work in the data security context is a different question that we'll maybe talk a bit about next, but certainly given what I consider the weaknesses in a process-based approach and the weaknesses in an approach that focuses on industry standards and statutory and regulatory compliance, the other ideas we've talked about, and those are just all inherently limited. This approach, if it could ever work in real life, is one that would have a lot to commend it. It's very similar to the approach that is followed in products liability law in determining whether or not product design was adequate. It's basically the same approach, and essentially what it's saying is we'll use the same approach for data security design as we use for product design. So in theory, and I'm talking about in theory, it's a very, very attractive approach.
Well, I will, you carry on. What would need to be decided for the cost-benefit model to work as a matter of law? I'll let you carry on with that, and then would like to get Tim's opinion on this afterwards.
Yeah, so as Chris was describing, one thing that would need to be decided is whether you can really do what Chris was describing. Can you really measure the benefits of an additional security control in terms of its reduction of the likelihood or the magnitude of a cyber incident? Can you really quantify that reliably in a way that a court or a regulator is going to accept it? As a litigator, if you can, then I like it. But can you?
Well, so I will say yes. And if I was working with you on a case, yes, it would prevail. Because there's you want to know two things. One, did the organization who actually did this evaluation, did they actually do something that was measurable? And you used two terms, Doug. One was measurable, which I am very comfortable with, and the other is quantified, and that I get concerned about. Measurable I like quite a bit because there are ways to measure things without them, well, let's say, measure multiple things, which you would need to do in a balancing test, right? You don't just have one thing you're measuring, but you need to be able to measure multiple things so that they're comparable. The challenge is, can you quantify everything the same way? And that's where things get dicey. I mean, I agree with you. If I were doing the HIPAA security rule risk analysis for a hospital, and the hospital says, well, you know, multi-factor authentication would cost me this much to implement. But if we use it in certain circumstances, it might be difficult to get to a patient's record when it's needed, and a patient might suffer. I'd be very comfortable to talk about the cost of multi-factor authentication, but I wouldn't want to talk about the cost of failed patient outcomes as a comparison to the cost of multi-factor authentication. Not only because it's distasteful to me, but because those are two different things. Patients don't come in to a hospital and say, I'll negotiate with you my care. Either cure this thing that you need to get to my patient record for in a protected fashion, or just give me the money that it would have cost to give me the treatment. It's not a financial discussion for a patient who's having, say, a hard time breathing, right? So if there's a way for us to measure the multiple factors in this balancing test in a way that is comparable, I think we've got the key. And the good news is there is such a method. The question that Doug, you're asking that still hasn't been answered is, how many times will that hold up? How many times will that model prevail in litigation? And that has yet to be seen.
Right, and I think the other sort of piggyback off that is, right, I think the example you gave, Chris, is great with regards to, but the thing is, everybody, judges and everybody can quantify, wait a second, you just brought in a human being's health into it versus somebody that I'm going to go to get insurance to drive my car, where that person's going to have all my personal information, but my health's not in. But how are they going to be able to protect? What are they going to be put into place? I think that's going to be the problem, where you're going to turn to experts to say, economists, hey, figure this out with there's a breach involving credit cards or something along the lines of where we just can't we can't show how much more, and it comes down to people want to see cost of money and so forth versus not what the cost was to the person. So, for example, like I said, like an insurer, they have Social Security numbers. That is true harm if those get loose,
Right.
and so forth. So I think that's, like, when you're talking about the different types of controls, I think one more thing you can take it a step further is that it has to be taken into place. When you do your assessment, what personal information do you have? And when you're quantifying your controls and so forth, if that makes sense.
So my pushback on that is that I don't think the fact that it involves people's health is really an issue. I mean, again, products liability, routinely, the harm that is worried about is health, actual physical injury potentially to people, and that's quantifiable. The real issue, and it really goes to the second bullet, is in cybersecurity. So often the harm is either intangible or not legally cognizable, and therefore it's unquantifiable because it's really, from a legal perspective, non-existent. And if you're applying a cost-benefit test and the harm that would go into the balance is a legal zero because it's non-existent legally as being intangible or not legally cognizable, then the cost-benefit test is always going to come down in favor of the defendant, right? So I think the hesitancy over this is more around the nature of harm that we're usually talking about in cybersecurity, or in the context of what Tim was talking about, the extreme remoteness of that harm in terms of being able to show, for example, identity theft flowing from a particular theft of a Social Security number. So, but I don't think that the health aspect of this is a blocker on this model.
I don't see it as a blocker. I just said the example is just, so to give another example, right? Supreme Court hates technology, right? They'll never take a case that involves technology and so forth. Same thing with, I mean, you run the risk of you're in federal court, you get a judge we'll call senior status and so forth. What I was getting at, what are they going to be able to relate to? Are they going to be able to relate to the example with the HIPAA example when you're talking about what that would do involving someone's health versus if you took the same case and you just said this was an insurance company that suffered a breach? I think because of all that goes in when we're talking about technology and how specific and how technical all these cases are, and it becomes like a battle of the experts, where that was my point, where I think it's easier to quantify if you throw in the real world example when you're talking about a judge or a jury, if that makes sense.
Yeah, I'm going to throw in too here that we talked about different kinds of costs here, which was very, I think, very illuminating. There is the risk of harm to individuals whose information may be exposed or otherwise compromised. And then there is costs for implementing security controls. But there are also costs to the utility of the reason why organizations joined in the risk to begin with, right? So there are ways to put controls in place that make an organization less effective, less useful to the public who want to engage in the risk to get the benefit. Now, what we're finding when we're doing risk assessments, and Doug, to give you further comfort, we've done, well over 100 of these risk assessments and represented clients when they've gotten into trouble with regulators and sometimes litigation. And the method at least makes sense to people as when those questions come up. I agree why that's I understand why that's different from what you're saying, but it's promising. What I'm getting at is that what we tell our clients is you're going to be looking at multiple factors, each that I believe can be measurable, but each must be measurable on their own terms. So I'm going to measure patient health outcomes differently than I'm going to measure, say, the success of research and development at a research hospital. And taking care of patients, health outcomes. Research of new meds, that's another metric I'm going to measure risk against, and the hospital's budget and patient privacy. What I'm not going to be comfortable with is equating all of those to the same dollar value if I can quantify them in dollar terms. What I'm very comfortable in saying is, let's find a way to measure each of these and talk about whether or not we think we've crossed the line into an unacceptable impact to our ability to do medical research and have good health outcomes and to protect patient privacy. So if there's a way for me to measure any of those things and then still relate them one to the other based on the acceptability of impact, I've got something. And we've found that carriers, insurance carriers, have found that to be helpful analysis when they're trying to figure out what the right policy is for their clients too. So just to keep in mind that I see where you're going in terms of quantifiability, but I wasn't implying that it's a deal breaker. Health things like that are a deal breaker, but we need to be able to measure things on their own terms. But I'm gonna stop this just quickly. Sorry, gents, and I know this could be its own panel, just you two going back and forth. Maybe that should be the Santa Monica. But I want to move on, and you mentioned the policyholders, and we really about the policyholder. We don't have much time left on this panel, sadly. So I do just want to get each of your opinions on what do you believe the key driver for a client is, or a policyholder company is, for seeking to achieve reasonable security. Is it litigation defense if they have an issue? Is it attack prevention? Is it appeasing insurers and getting a premium decrease? Just quickly, opinion from each of you on that, please. We don't have much time left. Chris, why don't you start? Sure. I want to be sure that my clients are speaking in terms of risk that everyone's going to understand. So there's a process written up by Center for Internet Security called CISRAM. It talks about how to evaluate risk in a way that regulators, litigators, insurance companies, and information security people all understand. So I just try to make sure that we've established that really strong, clear definition of what reasonable is based on risk analysis. That way, when there are decisions to be made either without a breach or after a breach, people at least understand what the intent was.
Thank you. Doug?
So I think the key driver for a client that's seeking to achieve reasonable security is a compliance driver, because that's what the law requires, is reasonable security. Again, whatever that means, and I don't know how much we've advanced the ball on that in this panel, but that's the key driver from my perspective.
Yeah, and I would echo a lot of what Chris said for the interest of time.
Thank you. With that, we will our final poll. What approach to reasonable security is best? Process-based, industry standard-based, statutory-based, cost-benefit-based, or unsure? And I think we are actually out of time and won't be able to take any questions, I'm afraid. If you any of the questions that have been asked through, we will look to provide to those. Thank you very much for listening. I'm very sorry I had to cut off Doug and Tim during that debate. I really do think that should be its own panel at a future Net Diligence. Thank you very much to my panelists, and thank you for listening. I hope it was informative.